Dear colleagues, time's running fast. We have very little time, so let's try and save it by starting early, despite the fact that there are not enough seats for all of you. So let's begin. Dear colleagues, our workshop will consider certain issues of improvement of the civil law of the Russian Federation, and against the background of the processes seeking to improve civil law which are taking place in Europe. That's why the speakers today will represent both the Russian side, my colleagues from the Private Law Research Center and the Council for the Codification of Civil Law, and on the other hand we're having here colleagues from Europe who will talk about the major trends in perfecting the legislation of European countries. You will know that our current civil code was developed between 1991 and 2006. 2006 saw the termination or the completion of the process, but in 2008 the President of the Russian Federation, Dmitry Medvedev, issued a decree on the need to modernize the civil law, the civil code, because the experience that had accumulated by that time, especially in improving the role of the judiciary in law enforcement, it had to be taken into account, as well as the practice of economic relations. Also, together with the improvements in private law in Europe. And the presidential decree of June 18th, 2008 set two tasks. One, to assure the stability of civil law. That is, we were not to change what was good and justified. It was considered a rather modern act regulating various relations of ownership and other aspects. But on the other hand, the people involved in the modernization of the civil law, including in the first place the researchers of the Research Center of Private Law under the President and the members of the Presidential Council for Codification of Civil Law. These experts, both academics and practitioners, were trying to prevent what had happened with other codes where amendments had been made without system and or order, like the Code of Administrative Offenses, the Criminal Code, etc. The civil law has avoided this destiny because in 1999 the president set up a council to codify and improve civil law, and instructed it to protect the civil code from arbitrary amendments, and the council was entrusted with the role of expert assessment of amendments to the civil law, and the council has been doing exactly this. It has held over 100 meetings, each dedicated to about a dozen acts or draft laws, and in total we examined some about 1,000 bills and draft pieces of legislation. So we have protected the civil code from arbitrary changes, but on the other hand, we had to bring it into conformity with today's requirements and to assure efficient legal regulation of economic relations. So this work has been done for 5 years now, and the Civil Code and the Private Law Research Center, as well as the Presidential Council to codify and improve to improve civil law. It was not all decreed from above. It was initiated from below, from the bottom up, at the initiative of lawyers and practitioners who were interested in our country having a good civil code. And the main initiator for such a private law center to be set up was Professor Sergei Alexeyev, who is sadly gone. He has died recently, and tomorrow, on May 17th, the Smolny Church will be holding the funeral ceremony dedicated to this outstanding theoretician and lawyer of modern Russia, and he was at the root of all this activity. We have a list of 12 speakers, both Russian and West European. We assume that each speaker will get 10 minutes for their presentations, and then we will have some time left for questions to be asked and remarks to be made. If you don't object to this agenda, let us begin. You know that Channel 6 is for Russian translation and Channel 5 is for English translation. Now I hand over to Andrei Yegorov, head of the staff of the Supreme Court of Arbitration of the Russian Federation, and well, there's a school of private law under the Private Law Center on my right, and on my left I'm having here the best alumni of this private law school. Sergei Sarbash is one of the first graduates of the school. He is an advanced, he's holder of an advanced doctorate and professor, and Andrei Yegorov is also a graduate of that school, and now head of the staff of the Supreme Court of Arbitration, and is soon to become holder of advanced doctorate. And now Andrei Yegorov. Thank you. Because our time is very limited, I will try to concentrate on certain provisions of the Civil Code pertaining to transactions and the period of limitation through the prism of an effort to indicate that this work of perfecting civil law was conducted and carried out while closely following the changes and amendments made to similar legislation in the countries of Western Europe. And of course, I won't be able to give you a full account, but I will try to give you some of the most important examples. And if you're interested, please consult the concept for the development of civil legislation, which was published in brief. But there's also the full version approved in the spring of 2009, and that full version, complete version, also provides motivations for the new provisions with references to the norms of civil legislation in Germany, France, the Netherlands, and other countries. And we were able to study their experience and tried to incorporate it in our own work. And I will try to show how this was done. I could mention, among other things, that Articles 169 of the Civil Code, penalty provisions were removed from it because if the transaction was conducted on a bona fide basis, previously, it was all punishable by the requisitioning of all revenue for the benefit of the state, but none of the Western countries had a similar penalties provided in their pieces of legislation. So we came to the conclusion there was no point in preserving this outdated provision. And it is a fact, and when this confiscation provision is gone, also in association with deception, threat, or violence, I think we have created conditions for the judiciary practice to verify the foundations for the effectiveness of the transactions, because deals are recognized as null and void if they were not made on a bona fide basis. And when arbitration courts you resort to Article 10 of the civil law. This is an indication of that, and one could either criticize that or support it, but I'm just stating the fact. I'm sorry I have to rush through examples. Now, we've expanded the idea of avoidance and now in a far wider interpretation than previously. Examples are given when transactions may be disputed. For example, one novelty is if the counteragent's personality was misperceived, and this is directly mentioned in the German code, the Austrian code, and the Italian code, and Spain, etc. And here are examples of how it was reflected. And now the current version of Article 78 of the Civil Law does not make it clear whether misperception of the counteragent's personality may be used as reason for the deal to be disputed, but now the actual practice gives a definite answer. And then we're now having provisions on the deception of the third party, third person, and the question is whether it's in all cases that you can dispute a deal. And based on most European countries' experience, although it's not uniform, Germany and Italy differ from France and Spain, but based on the prevailing tradition, we came to the conclusion that the wording of the Civil Code of today is a compromise. If the third party was a deceptor, but the person, beneficiary knew about it, then it can be disputed. And I could refer to the Italian and the Austrian provisions, the Swiss law, etc.
Next example, Article 174 of the Civil Code has been greatly amended. That's exceeding the authority or violating the limitations imposed by a power of attorney. Nevertheless, the attorney would not have the limitations, so that's about exceeding the limitations. Here, we were mostly based upon the direct rule, and we have found an analog in the Civil Code of the Netherlands, and there they have a stipulation to the effect that if a representative does a transaction, definitely not in the interest of the representee, but in the interest of the third agent, and if the situation is pretty straightforward, that means an abuse of authority, of representative authority. So we would not like to use the kickback as a description of the situation, because this is very difficult to prove anyway. But anyway, there is a definite case of abuse, and we can see that foreign laws fight such situations, like the German civil law definitely opposes this. In Holland, they have a specific stipulation preventing these situations. In the Russian Civil Code, we have a provision very similar to that in the Civil Code of the Netherlands. There is something else we have borrowed from the Dutch, but in fact we have gone further than them. We have introduced the rule of the assembly decisions. For example, in Germany, they don't have an assembly decision concept as provided by the Civil Code, not in detail anyway. In the Netherlands, the code adopted back in 1991 or 92, they have a provision with regard to assembly decisions, but they are not so well worded as the current stipulation in the Russian Civil Code. In Holland, they have a codification with regard to only corporate assemblies, corporate assembly decisions. We have gone further, and we have a relevant stipulation about shared property assembly decisions. It can concern lenders under a bankruptcy situation. It may be assembly decisions by other stakeholders of a certain civil community. Take any community, and they can decide that they do not use consensus, but they use majority-based decisions. In the corporate world, this idea is evolving really fast. Now we have borrowed something else from the Germans. It's the rule to the effect that if some property is disposed of with violation of the seizure rules, what are the remedies? The wording in our final edition of the Civil Code has undergone a lot of disputes, and the final edition is very similar to the relevant norm of the German civil law, which says that the transaction shall not have any consequences for the owner of the arrested property. Now, transactions with under no consent. The rules to this effect are in 172 through 175th paragraph of the German Civil Code. We have used similar stipulations in Article 157 of the new edition of the Code. Serious amendments refer to Article 172 of the new edition of the Code. That's about offense. That's about legal offense. It's different from the wording of the civil codes of Germany, Austria, or Switzerland. But anyway, we are saying that not any transaction in offense of the law is null and void. It is not indisputable or unchallengeable either. Other conditions apply in these cases. We are saying that only transactions violating public interests or the interest of third parties shall be deemed null and void. In other situations, the validity of the transaction shall be challenged, but there is no definitive rule. There will be judicial interpretation involved. Of course, public interest can be interpreted in different ways. Now, I shall just go over the list. Amendments were made to Article 183 to unify the code with the foreign law. That's termination of power of attorney if the represented party is bankrupt. Also, there is a complication where the power of attorney stays in the hands of the representee. Now, another point is combination of different statutes of limitation. So there is a 10-year limitation. If you learn about a violation during year 11, you may proceed with the case. And this is in line with most of the European laws, legislations, as they stand currently. Thank you so much. Do we have any questions? We have time for all questions to all the presenters at the end of our session. Now, Dr. Sarbash, please. Well, I've been invited to speak on the reforms with regard to the law of obligations. Right now, the draft amendments are considered by the State Duma. They are now in the process of the first hearing. I've checked the information, and I understand we're talking about 60 major amendments with regard to the law of obligations. Even if I speak faster than Dr. Yegorov, which I don't think I'm capable of, I believe that I shall have to discuss 6 amendments per minute, and I don't think I want to try that. So I'd rather discuss more or less generally the revision of the law of obligations and give you some examples with regard to certain novels which look most interesting. Now, generally speaking, the revision of the law of obligations involves diverse novelties, and most of them are pretty technical in their nature. They are based upon the analysis of the current practice of application of the provisions of the law of obligations. And this makes it very difficult at the law enforcement stage and at the trial stage. Some of the norms are rather brief, too concise in fact, and some of them are unclear. So the working group was set up by the working group under the President of the Russian Federation, the working group dedicated to reforming the civil code. The group was headed by Professor Vetryansky. So they have drafted a number of technical amendments. Let me give you one example. Let's take Article 314 of the Civil Code. Item 2 covers the rule applicable if an obligation has to be fulfilled within an uncertain time frame. So there are two paragraphs in the article, and paragraph 1 leads to conclude that the obligation has to be complied with within a reasonable frame of time. And in the second part, we see 7 days after the claim is presented, after presentation of the claim. So how do we understand when an obligation has to be complied with, to be fulfilled? From the article, it looks like it has to be done twice. So there should be an attempt to comply in a reasonable time frame, and if failing to do so, then you are supposed to do it in 7 days. During the adjudications, we have seen some very different interpretations of this provision. And a very famous professor, in fact, the father of the actual civil code, Professor Braginsky, used to explain that the time frames may be different. Some of them are set for debtors and some of them are set for the lenders. So we really have to discriminate between the two. There are some liabilities which don't have any time limitations, like a debtor should fulfill an obligation when a lender does not require him to do so. So a lender should be invited to accept the payment of the debt in due time. Now, when we're talking the 7 days requirement, it's kind of a combination. It's within the best interests of the lender, and he can require repayment of obligations. So the 7 days is in fact in the interests of the debtor. This example of an imperfection of the actual civil code proves that there was a need of revising the document. Some of the amendments were not really well deliberated. In terms of the law of obligations, a good example is the collateral law. It has been revised twice recently. Some of the revisions were technical, some were not, but anyway, none of them were good. And the legal practitioners have to face huge difficulties because of that. It was necessary to understand the reasons for those unfavorable amendments. Most of the reasons had to do with the recent financial collapse, the financial crisis, economic recession. So what could be the remedy? A very well-known and happily a currently living professor, Professor Makovsky, once said that we have a collateral code inside the civil code. It's in fact a multifaceted system. There are so many provisions at different levels with regard to collateral law. There is a number of other novelties brought forward by different perceptions of the current legal unifications. Some of those perceptions had to do with the sources of contractual law, and the famous commission of Professor Alivando. And we also used a well-known document, which is the draft Commonwealth reference, which is a certain prototype of the European Civil Code. We also recurred to unifications of other solid international organizations. Now, with regard to independent warranties, a good example would be the unified rules for contractual warranties. And they were lately developed by the under the requirement of the ICC in Paris. Each innovative norm in the law of obligations, before it is brought for the legislator's consideration, was tested for being in line or out of line with the foreign civil codes, first and foremost with the European civil codes, European countries' civil codes. Dr. Yegorov has broadly dwelt upon that, of course. It's been quite a piece of work, and the concepts of civil code development were broadly used by the drafters. There is another pretty interesting story, if I may say so, with revision of the civil code, especially with regard to the law of obligations. After the draft was published, there's been some criticism of the draft. And the media offered a broad coverage of that criticism. Mostly the criticism was generated by the big businesses. The drafters and the members of the council under the presidential administration dealing with the codification did their best to perceive the criticism. There's been a number of meetings of the so-called task force on setting up an international financial center. I'm not sure what the situation is with setting up the international financial center, but those meetings were quite instrumental anyway in revising the document. Some of the members of the task force are present here in this room, and they provided quite a few recommendations with regard to amendments. Some of the novelties are quite interesting, and some of them were bluntly borrowed from foreign legislations, adapted as was reasonably possible to the Russian civil law. Nevertheless, some amendments were pretty much samples of common law, the English common law. I do believe, though, that a number of proposals should be perceived as warnings for a conservative continental lawyer. Let's take an example. Let's say we're talking about depositing, which is better known as escrow accounts. This is a very specific tool, in fact. Let me confess from the outstart that I've always been pretty cautious, and I still am, with regard to this tool. It does invite quite a few theoretical and practical apprehensions and questions. Well, most of you would know what an escrow account is. The way it's described, the way it's presented in the Civil Code is as follows: the depositing party or the principal transfers some assets like securities or any kind of property, in fact, to the escrow agent, and the escrow agent sets this asset aside from the rest of his property, rest of his assets, and providing certain limitations in time, eventually issues it to the beneficiary, issues this escrowed asset to the beneficiary. Well, this is the overall scheme. I believe that a transaction like this can be effected even as we are speaking. There is nothing to prevent it. And I don't think there should be a special draft amendment to get it incorporated into the new civil code. But the interesting thing is that the asset is kind of hedged against anybody's claims. So in fact, it's kind of set aside and becomes a certain different type of proper asset. Like I used to make a joke that it goes out into the astral world, and nobody, neither the agents, creditors, nor the beneficiaries, creditors, nor the principal, nor the agent, can ever get any access to these assets or to this asset. Today, we've had a panel discussion of offshore transactions, and some people were saying that offshore companies are used to hide assets. Well, now here is another place, another domain to hide your assets, the astral world. But anyway, the creditors, the lenders, are now protected in an entirely new, different way. If ever somebody else goes bankrupt, the asset will not become part of the bankruptcy mass. This is a very good, a very valid example and an interesting one. I invite everybody to proceed discussing the amendments to the civil codes, to see other issues in revising it, and to present your own understanding and interpretation of the innovations and novelties of the civil code. Thank you.
Now, Alyona Kucher, Associate Professor of the Civil Law Subdepartment of the Law Department, Moscow State University. Thank you, and I'm happy that such an interest is being taken in our roundtable. My colleagues have mentioned the experience of foreign legislations, but I would take a step backward and look at comparative legal studies in the legislative process. Although briefly, I will dedicate half a minute to a small digression. I spent my past holidays at my country house, and as I was working on my patch of tomatoes, I realized what it had to do with modern law. I was faced with a choice of whether between using my seeds from the year before last and borrowing seeds from my neighbor. But for those seeds to bring similarly ripe and big vegetables, I had to create the same conditions on my garden patch as my neighbor has created. Unless I do that, then my tomatoes will not be like my neighbor's at all. And I hope you understand what I'm driving at. Unfortunately, in the modern legislative process, as we work on improvements in the civil code and the bulk of that piece of law, you will see two problems clearly. One issue is downright negation of the need to use foreign experiences, which is associated with exaggerated pride of one's own national law. And the other extreme is blind copying a blind copy of foreign pieces of legislation, and this will all give you lead you to the rising of rotten tomatoes, and we've had many examples of that. The attempt to implant the concept of trust in Russian law. Examples of failure to rely on foreign experiences are also numerous. For example, there has been long resistance to the idea of lease on a future object, and if you look at what happens abroad, this is one of the principles or important mechanisms of construction. Our pressing needs were asking for that, and this led to a very cumbersome practice of combinations between short-term and long-term contracts. And this was wrong because we had failed to look at the issue and how it was being dealt with elsewhere. Thank God we have finally overcome that and now are considering this possibility. Another example is the issue of warranties and representations. We blindly negate the need to or the possibility of protecting the information provided by one party to a contract to another party, and this may often be the reason for bringing contracts out of Russian jurisdiction into some foreign applicable law. And what we see now, they are trying to simply take it as it is from English law, and I think that both approaches are wrong. Of course, the turnover in the economy needs this kind of protection, and we should probably look at the beginnings of institutions that we need locally and then try to develop them. And apart from the efforts of lobbyists, the reason for such bumpy process is that we have comparative legal studies in a very rudimentary state, leaving the civil code aside, but the rest of legislative experiments do not follow the model. Comparative legal studies date back to ancient Greece and Aristotle's analysis of the constitutions of ancient nations. Then in the Middle Ages, the practice of Roman law was forgotten, but then it was revived, as can be seen in the German civil law or the French civil law, which had been preceded by very active legal studies. Because Germany was composed of quite a number of provinces, two of which were living under French law. So it was a rebirth of the comparative legal process. In comparative legal studies, there are three aspects. One is its role, the role it plays for the legislative process, and here I will quote from Jering, who said that reception of foreign legal institutions is not a matter of national origin, but an issue of reasonability. No one is going to carry from far abroad if you have something of a better quality, but it's unreasonable to reject the bark of quinine tree, if of the quinine tree, if it's on the simple ground that it grows far away. And then another aspect of comparative legal studies is the study for the need of interpretation of one's national law. And I could give you two examples. One is regard for the practice of foreign countries in dealing with disputes over unified acts. So one needs to look at what decisions were taken by the courts of other countries. Another example, which is very graphic, we had to resort to it as we developed a letter to the Supreme Arbitration Court on public procedure. You may have seen how they were trying to find an institution in foreign countries whose analog is missing from the Russian system. And it was a classical legal process. We were trying to compare institutions and we're trying to find what we were not having. And in the end, it was not that undisputable. It was again a matter of representations and guarantees. And the final thing I was going to say is that the issue with comparative studies stems from the educational system. We do not see comparative legal studies taught at our universities, and may I recall Edouard Albert, the organizer of the first Congress on Comparative Legal Studies over a century ago, who recommended that 4 lectures of comparative legal studies should be given to students per week in the period of 3 semesters. And of course we cannot do that much, but at least a more substantial course is needed for our legislative process to be built more appropriately. Thank you very much. I now hand over to Peter Wandt, Debevoise and Plimpton, Germany.
Thank you, Mr. Chairman, ladies and gentlemen. Thank you for this opportunity to speak at the International Legal Forum. I'm just looking at the screen, and there should be a presentation. Here we go. I'm deeply impressed by the depth of the research, analysis, and discussion in connection with the current reform of the Russian civil law. And I'm honored to present to you, as an example, how German law strikes the balance between the parties in connection with the acquisition of companies on the basis of traditional statutory concepts, but also on the basis of contractual concepts borrowed from Anglo-Saxon practice and that's important, translated into German law. I believe this is a good example of how important it is not only to borrow concepts, but also to make sure that they translated into the national legal system. Or to use Aljona's words, it's not about using only the right or the same seeds. It's about ensuring that the actual conditions for growing are the same. Could I have the next slide, please? It's not working. Oh, perfect. Yeah. Let me make it easy for you to follow my presentation. Here's my table of contents. I break down into 3 parts. First, I will give you an overview of legal concepts applicable to transactions involving the acquisition of companies. As you will see, there is a certain minimum level of protection in connection with the acquisition of companies guaranteed by statute. And you can supplement or replace these statutory protections by contractual protections. And here German law or German practice, to some extent, borrows from Anglo-Saxon practice. Here are the various concepts. Let me quickly run through them. In connection with the acquisition of a company under German law, the purchaser has minimum protection by statutory concepts of warranty law, culpa in contrahendo, avoidance, frustration of contract, and tort law. As I said earlier, the parties can supplement or replace these statutory concepts by custom-tailored representations, warranties, and indemnities. I strongly believe that the system of statutory protections should not be replaced by a system of buyer beware as you see it in other jurisdictions. It's very useful and it ensures protection for parties in transactions which do not have the benefit of being able to pay for legal advice. After this introduction, let me dive into the various statutory concepts. You see them on this slide: warranty law, culpa in contrahendo, avoidance, frustration of contracts, and tort. Which concept applies to which case? The answer depends on whether fault of the seller can be established and the remedy sought by the purchaser. As you know from your own practice, establishing fault is tricky. Therefore, in practice, for the courts, warranty law and culpa in contrahendo are the most important concepts. They do not require intent. Warranty law generally does not require any fault. And for culpa in contrahendo, the showing of negligence is sufficient. The courts go after the real crooks on the basis of avoidance and tort law. Let me elaborate a bit on warranty law. Warranty law applies to both the sale of rights and the sale of goods. It was not designed for the acquisition of companies. The original German civil code is over 100 years old. Its warranty law provisions were meant to provide a framework for day-to-day transactions, like the sale of apples or a piece of furniture. German courts had to fill the gaps, and they did so successfully. When the German Civil Code was amended in 2002, many case law decisions were actually codified. German warranty laws distinguishes between defects in title and defects in quality. The concept of defects in title provides only limited protection to the purchaser of a company. Basically, it provides protection where the seller sells you shares which are encumbered. They have a lien on them. Therefore, German courts turned to defect in quality rules regardless of whether it was a share deal or an asset deal. Courts deem a share deal to be an acquisition of an enterprise if a purchaser acquires more than 75% of the shares. Courts deem an asset deal to be a sale of an enterprise if a going concern is sold, i.e. a business. Now, what's the defect of an enterprise? A good question, and here the tricky part starts. The German Reichsgericht, the predecessor of what is now the Bundesgerichtshof, had to decide a case more than 80 years ago where a hotel was sold, which turned out to be a brothel. Well, you can still sleep in those beds, but that was not enough for the judges. They found that to be a defect in quality. There are many other examples, and a more recent one is the sale of a scaffolding business by way of an asset deal, where the majority of the scaffoldings certainly were faulty. It is important to understand that German courts do not regard mere turnover figures as something which can constitute a defect in quality. Turnover figures or other financial indicators are dealt with under the concept of culpa in contrahendo. The question there is whether the seller provided adequate information. They're not dealt with by warranty law, since this financial information is deemed not to be inherent to the enterprise. Now let me turn to contractual concepts. I'm sure you have heard about these before, you have seen them in practice. Representation and warranties, specific indemnities, covenants, and the indemnity clause. The terminology sometimes is tricky, and I've divided the categories as follows. Representation and warranties in a contract are statements of fact, but German law allows you to make them the basis of a contractual guarantee. They apportion the risk between the parties for unknown potential issues. To give you an example, I, as a seller, declare in the contract there is no litigation regarding the company. Specific indemnities come into play as a matter to apportion the risk for known potential issues. I'll give you another example. The premises on which the company operates and which are part of the company being sold are polluted. That's the case for many industrial companies. The pollution itself is there and it does not harm anybody. It's in the soil, it's contained, but there might be an issue sometime in the future if the contamination starts polluting the groundwater, which currently it does not. Here the parties know that there is a risk, but the financial effects of that risk are unknown. So they would agree in the contract that in case the risk materializes, one of the parties will pick up the bill. Covenants define the obligations after signing, and the indemnity clause finally deals with the question of remedies in the case of breach of contract. As I said before, There is no specific statutory basis for this. But German law allowed the incorporation of these Anglo-Saxon concepts on the basis of freedom of contract. These remedies help to supplement the statutory protection for parties which are sophisticated. They're not suited for everybody. The reception of these concepts basically took place in the 1980s. Before that, Germany was a country where you had lean contracts and small law firms. But then you had more and more American and US lawyers coming to Germany. The M&A practice grew more and more international. And German practitioners decided, rather than having their contracts governed by foreign jurisdiction or by foreign law, to translate the concept to the extent possible into national law. Let me conclude with a quick look at the advantages and disadvantages of this reception and the concept of reps and warranties and indemnities under German law. This regime allows you to custom tailor the liability regime to address the needs of the parties and the specifics of the transaction. It's very transparent for the trained eye. I like to use an acronym which was developed some 10 years ago in connection with text processing. It is what you see is what you get. When IBM still gave you this awful DOS screen, you could not see what your printout would look like. In a long contract, the parties can, if they understand what the contract is all about, see what rights they have rather than referring to a code. But they need to understand what's in there. And it avoids certain uncertainties associated with statutory concepts. However, there are clear disadvantages of this as well. It's complex and expensive due to the need of legal advice. And it's not suited for unsophisticated purchaser in small transactions. Imagine a grocery shop owner in St. Petersburg who wants to sell the shop. He's certainly not prepared to pay for a bunch of M&A lawyers working on the transaction documentation. And he should not be forced to do that. It's important in my eyes that there is a statutory concept as a default regime. Thank you very much.
Thank you very much. Thank you very much for sharing this most interesting experience. And now our next presenter is Nick Kutnax, representing the same company and based in Great Britain. Thank you very much. As an English lawyer, I shall have to somewhat step aside from the subject of my presentation, which is the reception of the English law institutes in the country, in the states of continental law. I shall do a little bit of a disguise here now. This subject actually arose before the financial recession. A lot of business associations and financial institutions spoke in favor of importing the common law into the continental law system, especially in the evolving economies, either in full or in its most important part. The most significant favoring party was the World Bank. They have that Doing Business annual publication you might be aware of, and its principal part is dedicated to the regulatory regimes around the world and the way to amend them to generate a more efficient business environment. As I was preparing to make this presentation, I went through several of those annual publications. And the intensity of advocating for the continental law grew gradually all the way through year 2008. the English law and the common law was described as an investor protecting law. But in the year 2005, the Doing Business publication, the Doing Business paper, just plainly stated the overregulation of the overregulation situation. That too many legal norms is bad, and we need to reduce the regulation, and the common law is the most efficient tool to increase the overall efficiency of the business. The British legal researchers or the legal scholars were saying the same in those days, but this doesn't look like a truth set in bricks and mortar as we're speaking today. The president of the World Bank has recently said that in his Doing Business paper back in year 2000 plus shall be now revised. And he's now saying that overregulation is not as bad now, and too many legal rules and norms are not always good. So with this regard, I would like to quickly consider two different sets of issues. The conceptual issue of the import and reception of the English law in the continental law countries. Now, taking the conceptual issues is, of course, focused around the role of judiciary practice. Judge Pound, which is a well-known scholar, once said that the empirical tradition, which is so much part of the common law, provides huge capacity for growth, not provided by any other legal system. I am literally surrounded by continental lawyers, so I will not dwell upon what I think of them. This judiciary practice basis, which the English law was so much centered around, and which is now spreading, is a really significant basis of legal practice. The legal practice cannot exist without it. The common law countries like the US, Canada, and Australia normally refer to the other common law practice, like English and American legal practice would be often cited there, as well as a number of transactions taking place in New Zealand and Canada. All those transactions in all those countries are broadly discussed, but conceptually the problem is as follows. If we introduce some concepts like warranties and indemnities, or the Institute of Trust, transplanting all that into continental law, we can look at this from a different angle, as Dr. Kucher has described when she was talking about her tomatoes. If we try to plant the Trust Institute to the continental law countries, we need to get them some roots, and the roots are the judicial practice exactly. Warranties and indemnities is a great institute used in all the M&A transactions, and it's like water for any tomato transaction. There are a huge number of all those little tiny roots, which are sub-norms, sub-rules. If a seller gives you a warranty with regard to some fact, he can then say that the warranty is incorrect. What do you do if you know from a different source that the warranty is wrong? What is the rule? What if you just introduce an institute without having all the proper rules? A legal vacuum is what you eventually get. There is a relevant convention which has not ever been too popular in the continental law countries. So with this regard, some Chinese experience is interesting. In the early 2000s, when China was considering introduction of the Trust Institute, they were greatly tempted by just legalizing great number of harmonizing their legal practices with the Hong Kong regulations. It's one country anyway, but they did not go that way. They were really concerned with the Classical Trust Institute providing for constructive trust possibilities when the two parties may not be willing to set up a trust, but a trust can be actually set in an oral form. So they did establish their own law, which introduces the concept of civil legal trusts. And property of a trust has to be registered. There is no trust that can be set up automatically. There should always be a written agreement. And there are all kinds of apprehensions related to that. They set up a concept that they needed to become an international player, but they created that concept on their own terms. So in fact, they provided their own roots to their own legal system. Now, the second real practical obstacle that I can see here is the difference between, as we lawyers say, the difference between the different mentalities of legal practitioners. As Peter said, the caveat emptor is pretty alien to most of the continental lawyers, but that's where the English lawyers normally start, and the common law lawyers normally start with. Often it happens that continental lawyers have to work with the common law for their first time. Then they get an impression that the common law allows lots of things to be done. They have less binding rules as compared to the English law, but you cannot capitalize on this. If you draft a two-page agreement, which can exist under the Dutch or under the German law, and these two pages can protect you, but they cannot under the continental law. Now, to conclude my presentation, I have to say that the English law is a good example of a system that serves businesses well. It has some institutions that have been borrowed by the German law and some other continental lawyers. But if you remember the mentality of legal practitioners, you want to use the existing tools and you just want to develop them further on. That's it. Thank you. Thank you. And we now have a new speaker. And our next speaker is, and actually we shall shift the seats. We invite the next four speakers to take their seats at the panel table, please. I would now like to invite Dr. Rudokvas, Dr. Willems, Dr. Van Erp, and Dr. Bevzenko. Do take your seats at the table at the top, please. Shall we proceed, esteemed colleagues? Now, I'm happy to grant the floor to Professor Sjeef van Erp from the Netherlands. Professor, the floor is yours.
Ladies and gentlemen, Mr. Chairman, good afternoon. Given that I have only 10 minutes' time, I could show you my PowerPoint presentation, but I think I will not go further than this one. I want to focus, given the time limit, on two aspects. The impact of digital content, the use of digital content in contract law and property law, and talk to you briefly about an aspect of land law, that is when you have land and you build on it, who owns the building? And in that respect, Russian law differs very much from what you see in continental Europe and in the common law. Before I can talk about digital content, I must say something about a development in Europe more generally, because I need that. Some of you may know about the American Law Institute. That is an institution about now almost 90 years old, developed or established by practitioners and academics to further develop American law, and they are very well known for their restatements and for some model laws. Now, based on that model, 2 years ago in Europe, the European Law Institute has been founded, which has its secretariat in Vienna. We do the same, and I can say we because I'm one of the co-founders. We also try in a non-partisan, non-national way to develop European law. One of the first 2 projects we had was commenting the draft Common European Sales Law. Now, that has already been mentioned, but not under this term. What has been mentioned is the draft Common Frame of Reference. Now, originally, the European Commission wanted academics to draft a sort of small type civil code in the area of consumer contract law. Then the drafter said, no, let us develop a European Code of Contract Law. Then tort was added, then property. But at the end, in the final stage, the political stage, it was decided that the final proposal to the Council of Ministers would be contract law. And during the political process now, what has changed is that it is no longer about sale of goods particularly, but of sale of digital products, digital content. It is now more and more realized that given that more and more business is done electronically, you need special rules for that. When you download a product, is that sale of a good? I can give you one example based on case law of the European Court of Justice, a recent case, the Used case. You download a particular program. You get a license for which you pay, but you have unlimited use. You then give the license to someone else. Can the person who holds the intellectual property right in the software say, but this is not going to happen. I will not accept that that other person now can download my product. The Court of Justice, however, has ruled that you can. So the license, which is essentially a contract, is treated as if it were a good that you can transfer. This poses enormously complicated questions for lawyers, in practice and in theory. Because from this perspective, what is a good? What is a service? What is digital? Do you need for a digital transaction that it is somewhere attached to a device, a hard disk, or can it be in a cloud? But then do you have co-ownership in a cloud? How does that work? Well, the Common European Sales Law, in fact, as it stands now, focuses on that sort of problem. And what you see there in Europe, in the European Union, is that we can agree on uniform law if it escapes national borders. If we all know that it doesn't make sense to have your own law in that area because digital transactions, almost by definition, are cross-border. Quite difficult problems are if there is no choice of law, what law to apply, etc. So this is one aspect I want to lay before you. The recent developments in the European Parliament regarding the Common European Sales Law, and I would urge you to have a look at the website of the European Law Institute, because we as an institute are very much involved in this process, commenting on the amendments made in the European Parliament with regard to the Common European Sales Law. Our working group for this project is chaired by Sir John Thomas of the Queen's Bench Division in London, simply to show you that for us, this distinction common law, civil law does not really exist anymore. We just want good law. My second point. Land law. That was suggested to me to talk about that briefly. With regard to land, you can have two approaches. You can have the so-called vertical approach, as you know. When you own the land, you own buildings on the land. You can have the horizontal approach, that you separate ownership of land from ownership of the building to begin with. It's a different starting point. If you have the vertical approach, which you find in, I would say, Western Europe generally, and if you then want to create ownership of the building separate from ownership of the land, you must somehow create a new property right that separates ownership of the land from ownership of the building. This can be done in some legal systems by the mechanism of a property right called emphitosis. It means that, for instance, a local council, a community is owner of the land, but someone else gets a long period of time to use the land in such a way that you can sell and transfer the use. Question and still is, what happens when you build, for instance, a house on that land? In some legal systems, building a house would still mean that the owner of the land would own the house. In other legal systems, if you have a right of emphitosis, you become owner of the house. If you have a system where when you build a house, you become still, or ownership of the house still will rest in the hands of the landowner, you will need on top of your right of emphitosis a right of superficies to create full separation. This is the way it works when you have the vertical approach. When you have the horizontal approach, what you have in Russia, of course it's clear that ownership of the land does not mean ownership of the building. So you need separate rules for ownership of the building. But how do you create those rules? How can they look like? Can you do it through an ordinary contract of hire, of renting land? If you follow the strict civil law tradition, hiring land is contractual in nature, so only creates personal rights and duties, which means that still you have not said anything about who then owns the building. If you hire the land, you're entitled to do something with it, but if you build on it, you still have not answered the question, then who owns the building? You need a separate rule for that. Or you must imply in the contract of hire that the lessee, the person who hires the land, also now becomes implicitly the building's owner. But if it's an apartment block, what do you do with the separate units? Are they then sub-hirers or sub-owners? You can, of course, follow the approach of a common law and say, well, lease of land creates a property right, a property entitlement. But then you should realize that you are creating a new property right, as such, unknown in the civil law. There are examples, in South America, for instance, there are examples. But you must be careful when you introduce, and it has been discussed already, when you introduce common law concepts in a civil law structure. Essentially, those are the points I wanted to talk about. Didn't want to talk very long. This is a long session of 3 hours, but I had 3 points. The European Law Institute, and I would urge you, whether you are from within the European Union or outside the European Union, you can become a member, be involved in the work of our institute. We already have 700 members, and they include, for instance, Supreme Courts like the Supreme Court of the Netherlands or the Court of Justice of the European Union. So become involved in the work of our institute, that was one. Second, I wanted to draw your attention to recent developments regarding the Common European Sales Law, which focuses on digital content, which cuts across the almost now classical distinction between B2B and B2C contracts. Because also for a trader, dealing with digital content means that you are at a disadvantage. And I wanted to draw your attention to an ongoing debate, I understand, about, well, how do you, in a regulated way, separate ownership of the land from ownership of a building? I know it's 3 different topics, but I thought it worthwhile putting them before you. Thank you very much.
Thank you very much. It was a very interesting presentation. Now, Mr. Bevzenko, Roman Bevzenko, head of the Private Law Authority of the Higher Court of Arbitration of Russia. Good afternoon, dear colleagues. It's a great pleasure and honor for me to address this meeting. My subject today is a brief and cursory overview of the novelties that have come into effect as the first law in a series has been adopted to reform the Russian Civil Code. And I would like to comment on the new norms that are concentrated in Article 8.1 about the registration of state registration of title to immovable property. I would first like to mention the sources for my presentation, and I would like to quote from a statement by one of the managers of Apple as they were presenting iPad 2 or iPad 3. It was not revolution, but evolution, and I would use the same formula. The norms concentrated in Article 8.1 are in fact, an attempt to structure and systematize the provisions that had been there in our laws, especially provisions about the state registration of title to immovable property. Although some intellectual effort, it took an intellectual effort to make it more systematic and turn it into a concise formula that this article presents. Here I would like to characterize the registration system that has finally emerged in Russia. International experiences tell us that there are 2 types of registration systems depending on what is the object of registration. First, registration of transactions, when any transaction with immovable property has to be registered, and based on who was the last to register a deal, the decision is made about who is the owner. That's referred to as the French registration system. The second type of registration system is the registration of title, when it is not based on the transaction but on the object, such as a land plot in the land book. Our Russian system, before it was reformed, was a mixed one, because the main idea was to register title, but in some cases transactions with the immovable property were also registered, and the choice of such transactions was this. what had to be registered were transactions with encumbrance, such as lease contracts or hire contracts, and the other type was the type of it was a socially significant type involving people not very well versed in law, owners of apartments, and of course legislator tried to help those people and wanted such transactions to be registered. But practice has shown that this idea of protecting parties to such transactions failed to be efficient, because it has evolved in a formal procedure of two applications filed at the same time, with contract registration and title registration taking place at the same time, so it had no visible effect. And a small digression here as well. In my view, the registration of transactions with immovable property was partly associated with the fact that the phase of the initial phase of the development of the Russian Civil Code was driven by the desire to abandon notarization of immovable property, and perhaps they thought that the registration of transactions would be tantamount to their notarization, but they were unable to introduce a good new notarization system. And as part of the reform underway now, an attempt has been made to add the idea of notarization of transactions with immovable property. So far, this has not been implemented, and I don't know what it may lead to, and I'm not going to go into that. Another characteristic of the system to be built in Russia is it relies on the legal significance of the entry in the register. Traditional systems are classified into negative and positive. Negative system presupposes that an entry is equivalent to title, and I mean the positive system. And the negative system assumes that it is not sufficient. There have to be legal grounds for it. There's a compromise between the two types of registration systems. A registration system protecting a bona fide acquirer. So when someone has entered into a transaction on a bona fide basis, but subsequently finds that it was not purchased from the owner. So this Russian system is tending in favor of such a compromise solution. There are advantages of the positive in the positive registration system, of course, but so far it is like that. The next principle I'd like to mention is the principle of mandatory records for a title to emerge. In the new version, it has been clarified, I think. The need for records has been made mandatory, but also the law states cases when transfer of title takes place due to unestablished legal fact without a record, such as in the case of inheritance or succession. The principle of record legality of records or entries it has also set the limits to legal verification of the entries to the registers, and what has been implemented here is the distribution of labor between the notary and the registering authority. The principle of openness of the registry's openness is another basic principle which has been clearly stated. And the last thing I'd like to mention is the principle of registry specialty, which is worded in Part 1 of Article 8.1, which says that the registry should include data making it possible to definitely determine the object of ownership. And contrary to the prevalent tradition today, a building is not considered as a movable property, but as part of the land plot. And I hope very much that this provision will soon become law, and for owners of land plots, a brave new world will appear, and there will be a time when if you build something on your own land, you won't have to register that new building.
Thank you. Your comments? Could you please use the microphone? No. Sorry, please use the microphone. The booth is not getting it. Well, if we do announce a coffee break right now, we shall lose lots of time. Shall we please proceed with no break? Thank you so much. Thank you. We are patient people here in Russia, and our guests are very patient as well. Yeah, well, thank you for that. And our next speaker is Professor Willems from the Netherlands. Professor, the floor is yours.
Ladies and gentlemen, as our distinguished and tough moderator, Professor Yakovlev might know, today, the 16th of May 2013, it is precisely 7 years ago that I had the great honor to address the students of the distinguished Russian School for Private Law in Moscow. Today, I am honored to have been invited to address your audience at this special occasion on, amazingly, the same topic, be it this time in St. Petersburg. The concept of corporate governance, being my topic, is not in every respect clear. It is just a rough indication of the subject we are talking about. It includes company structures, the way in which the powers of the bodies of the company are distributed and exercised, the way in which board members account for the management of the affairs of the company, how rights of shareholders can be exercised, what the duties of a supervisory board are, how companies are governed, and the like. In general, corporate governance is a general term for anything that falls within the ambit of making the company function. For my presentation, I would like to make a distinction between two categories of rules of corporate governance. In the first place, one can point at the legal rules in the Russian Federation, mainly to be found in Book 4 of the Civil Code, concerning the structure and the functioning of companies. So, for instance, the rule that the board of a company is in principle exclusively empowered with managing responsibilities for the daily affairs of the company, the rule that in some cases the board of directors need the previous consent of the supervisory board for entering into defined categories of transactions, and the rule that in principle all shareholders have to be treated equally and have equally to be informed are rules of corporate governance. But they also are binding in law, and any interested party can these rules have enforced in court. In the second place, there are the rules of corporate governance in the more strict sense of the word, which are to be found in codes. One of the peculiarities thereof being that they are not enacted by the legislator, but by private parties without legislative authority. It follows directly from this that rules contained in a corporate governance code will not in itself have force of law. On the other hand, it is quite unimaginable that in the whole modern world, codes of corporate governance are being discussed and enacted just for the fun of the draftsman, but without any impact on the way companies are being governed. In the Netherlands, a corporate governance code for listed companies came into existence in 2003. The code is based on the principle accepted in the Netherlands that a company is a long-term form of collaboration between the various parties involved. The stakeholders are the groups and individuals who directly or indirectly influence the achievement of the aims of the company. In other words, employees, shareholders, and other providers of capital, suppliers and customers, but also government and civil society. The management board and the supervisory board have overall responsibility, generally with a view to ensuring the continuity of the enterprise. Good entrepreneurship, including integrity and transparency of decision-making by the management board and proper supervision thereof, including accountability for such supervision, are essential if the stakeholders are to have confidence in the management board and the supervision. These are the two pillars on which good corporate governance rests and on which the code is based. The principles have been elaborated in the form of specific best practice provisions, as for instance, the provision that a supervisory board member shall retire early in the event of inadequate performance or structural incompatibility of interests. Unconditional freedom to decide whether or not to apply the code is not desirable in international legislation and codes. The flexibility is limited by the obligations of listed companies to explain in their annual report whether, and if so why, and to what extent they do not apply the best practice provisions of the Corporate Governance Code, known as the comply or explain principle. And the Dutch legislator has given the Corporate Governance Code some statutory basis by including a provision to that effect in Book 2 of the Civil Code. But the important question, of course, is whether the Dutch Corporate Governance Code will have effect in law, and if so, to what extent. The first question has to be answered affirmatively, which raises the question how that is possible. And the answer is the typically Dutch inquiry procedure in the Netherlands. Article 345 of Book 2 of the Civil Code empowers certain categories of interested parties, for instance shareholders, to request for the affairs of companies and other corporate institutions to be investigated on the ground that there are fair reasons to believe that the affairs of the company or institution are not managed properly. If, after the investigation report has been finalized, bad management of the company appears, the court has a wide variety of orders to its disposal to intervene in the company and its affairs. It can not only declare that the company was badly managed, it can establish who of, for instance, the directors is to blame, and it can, if it thinks fit to do so, for instance, dismiss executive and non-executive board members, appoint executive and non-executive board members. It can annul decisions of the board, of the general meeting of shareholders. It can alter the articles of association and suspend voting rights. It even can liquidate the company. It is within this special jurisdiction and the corporate litigation that principles of corporate governance enter into the legal field. This analysis leads me to make 6 remarks of a theoretical nature, probably applicable in any jurisdiction that promotes good corporate governance. In the first place, the principles of good corporate governance do not focus on rules that structure the company, the division of powers, voting rights and the like. They focus on how rights and powers are exercised and on corporate behavior. Secondly, as in many jurisdictions, in the Netherlands, the rules in the statute concerning corporate behavior are vaguely and broadly formulated. The most important Dutch article in this respect is Article 8 of Book 2, by only saying that those who are involved in the company must conduct themselves according to reasonableness and fairness. Thirdly, a standard such as fairness is and remains an empty shell unless it is given content through court precedents. Fourthly, the question whether corporate behavior is in line with the prerequisite of fairness is not answered ex ante, before the behavior took place, but always ex post by the judge. And from there it follows, in the fifth place, that businessmen may expect judges who have to decide on business conflicts to understand what is business about. And for that reason, it is not uncommon to have specialized courts, sometimes even composed out of businessmen as well as lawyers. And I would suggest the Russian arbitration courts and the Dutch enterprise courts are modern examples. And finally, whether or not corporate officials or involved persons like a shareholder do meet the standards of fairness depends heavily on the specific circumstances of any given case. There are no hard and fast rules. This is the consequence of the nature of the principles of good governance, as compared with rules of the law. In the famous Dutch case of ABN AMRO Bank, the biggest takeover battle concerning a bank in the history, in which 73 billion euro were at stake, the Supreme Court defined the Corporate Governance Code as expressing the generally accepted legal conviction. I might end my presentation with the following quotation. It runs like this. Legislation alone cannot be expected and is inherently unable to regulate all issues related to the management of companies. First, the law establishes and should establish only general mandatory rules. Second, legislation is unable to react rapidly to changes in corporate governance practice, as amending laws is very time-consuming. At the same time, such legislative regulations are not always sufficient to ensure proper corporate governance. Therefore, companies should act in accordance not only with statutory standards, but also with ethical standards, which are often more demanding than the law's requirements. Ethical standards present a set system of behavioral norms and customs of the trade traditionally applied by the business community. Ethical standards of corporate governance form sustainable behavioral patterns common to all participants in corporate relations. That is what is corporate governance all about. It confronts all of those who have responsibilities within the company with the paramount principle of acting in good faith in the interest of all who are involved in the company one way or another. That's the end of the quotation. 7 years ago, I did ask the students of the Russian School for Private Law whether they did know where this quotation was taken from. No student had the right answer. The right answer is, it is a quote from the Russian Code on Corporate Governance. See it the Russian way, I therefore would say to you. You can therefore imagine why I did label my address to you as follows. Corporate governance in the Netherlands, from Russia, with love. Thanks for your kind attention.
Thank you very much. Thank you very much. It's been a most interesting presentation. Now we have our next speaker, and that shall be Professor Ruda Kvass, Associate Professor of Civil Law at the St. Petersburg State University. Thank you very much. Frankly, when I got an invitation from Professor Makovsky to make a presentation dealing with possessory protection at the St. Petersburg Legal Forum, I felt embarrassed just because I found myself to be the only Russian speaker not only involved in the civil code revision and modernization. I was actually the person who was heavily criticizing the draft revised version. But we can remember Confucius, who said that he who wants to improve the world should speak the right words at every square of the city. So today I shall voice my attitude, my position, even if it's not very complimentary with regard to the project of revising the Civil Code of Russian Federation. The very idea of introducing the concept of possessory protection, unanimously adopted by the Russian legal community, civil lawyers community back in the 1990s, is still very doubtful to me, even though it's present in all the legal systems of continental Europe. On the other hand, its implementation, the implementation of this concept in the Civil Code remains disputable for me, and I shall try to present my arguments to this effect during the limited time I've been allocated. Now, with regard to possessory protection, we can say that it's part of the European law, of the various European legislation, but we have to remember the arguments in favor of its justifying its very presence. These arguments are not relevant to the Western European countries nor to the Russian Federation of today. So what is the first argument? It says that having the possessory protection allows to free the turnover stakeholders from having to prove their rights, which is not always practical and sometimes may be quite difficult and demanding. But we have to remember that the concept of possessory protection was born many centuries ago when there was no state registry of property rights. That was the probatio diabolico time. The diabolical proof is the translation of a phrase. When right of property is arbitrarily acquired, you had to not only to prove the last leg of the sale and purchase agreement, but you had to prove all the preceding transactions, which only the table is capable of. Today, with the state registry system of property rights, immovable property rights, with the courts that now follow the French doctrine, which says that to prove the right of property, you only have to prove the latest acquisition, the last acquisition. You don't have to go all the way down to the beginning of the chain. So the possessory protection is only needed as an institution facilitating the protection of the proprietors. But this is not really a valid argument, not any longer. The second argument reads that possessory protection shall be granted whether there is or whether there is no property right. And allegedly, it serves combating arbitrary decisions. As far as I can remember, the Civil Code, it's exactly the arbitrary actions that invite the institute of possessory protection. But raiders' actions, as we see them now, are very often resulting from proprietors' conflicts. Very often, two directors general and two security services fight one another, and each party would claim to be to express the will of the economic entity. And this is not where we need the possessory protection to come into play. So having no possessory protection in the current civil code is not really compensated by the vindicative claims or other types of claims provided for in the civil code, in the current civil code. Analysis of judiciary practice and analysis of civil code application was carried out by a group headed by Professor Belov in Moscow, and they only identified one judicial case when a vindictive case was related to a radar action. In other cases, the situation was regarding to the vindication of a third party who was a buyer of a piece of property. The same analysis identified only 3 cases of the claims against a proprietor of long ago, and this seems an appropriate application of the proprietary protection. We have to remember the claim of publician. The term is still used in the Germanic law. Publiciano law is also used as a concept in Italian law. The concepts are pretty much alive there, even though they've been somewhat modified. So the Russian law is not alone here. The arguments in favor of introducing the possessory protection into the Russian law and order are not really there, but also there are no such arguments that can be used to protect the transaction stakeholders from any arbitrary actions, from abuse of possibilities. There are some logical contradictions in the very text of the draft law. These contradictions or discrepancies partially relate to the fact that Russian legislators, based upon Western experience, decided to set up an original possession concept. But they ruled out some components of this concept rooted in the Roman law. I don't think I can analyze the text of the draft law. I've prepared the presentation for this, but I'll only cite some examples. Practically all the European legal systems know the binomial of separating the holding versus proprietorship, or direct holding versus an indirect holding. The Russian legislators decided to go without this discrimination, and under the Russian law, the proprietor is the actual or the factual holder. When a piece of property is leased, then the holder shall be the tenant, not the lessor.
As a result, the current judiciary practice will be changed in 2 aspects, and I will remind Russian lawyers of the fact that our Supreme Court has decreed that the hiring of an object it does not interrupt the duration of ownership, but with the new amendments, this will not work. It will not continue for neither the lease taker nor the lessor. Now, when an object is leased or hired, now settlements are performed, effected with the lessor, but the new system will make it impossible. Though there will be a domino effect generating quite a number of issues. On the other hand, it's understandable that the authors of the bill want to keep intact the definition of ownership as a physical condition because there's protection for both the owner and the thief. They are both categorized as protected owners, but you cannot consistently stick to this approach. And let me give you one example. The bill says that broken ownership is not considered as lost if the entity or person has resorted to ownership protection. If ownership is protected as a fact, then after it is lost, there's nothing to protect. So why should we protect, should we meet the owner's action? That's why the legislators have decided that ownership continues if one resorts to protection remedies. And another provision requires that the owner should prove ownership, which is again a contradiction. The person that has lost ownership is still considered owner, but the acquirer is not considered as owner for a period of 1 year. And now the last example associated with with failure to use foreign experience. The Western concept includes the so-called tort. Respondent of an action may be a person who had intent in acquiring captured property, and Carl Sauvigny provided reasons for complicity of the acquirer in this tort. But the Russian law states that any subsequent owner becomes acquirer becomes owner regardless of whether there was intent or knowledge of unlawful capture. The draft law proposes several methods of protection, including administrative, police methods, and self-protection. So what happens is that bona fide acquirer, the former owner may simply take away the property sold because self-protection is allowed. I just want to mention that a video recording of my lecture is available on the website. Its length is 2.5 hours. Thank you very much for a very interesting presentation. We are having another change of speakers for a third time. Please come up to the panel. We are continuing. Now I call on Yelena Pavlova, head of the Department for Legislation on Intellectual Property. Good afternoon. You have 10 minutes. I'll try to keep within the limit. I will discuss Part 4 of the Civil Code, the newest one, which came into effect on January 1st, 2008. And no sooner than we had completed it, we started amending it. And it looks like a continuous process and has been going on for a decade or more. And for me, it falls into two phases. Phase one was the drafting of this part, and in that period, the working group faced the task of receiving and interpreting foreign experience, although it was a new experiment to codify this legislation. But one of the tasks was to incorporate TRIPS conditions, because Russia was preparing to accede to the WTO, and it was the issue of implementing it in various WTO countries. And so we looked at European legislations like French, Germany, the Netherlands, Scandinavian countries, England and the United States to some extent, and of course it's understandable that the emphasis was made on continental law. Here, slide 1 mentions the EU directives that were used with all evidence and almost directly. We awarded two new types of copyright-associated rights, the publishers' rights and the database makers' rights. It was and Article 1293 on the right of succession was revised. We used still more European experiences in the next phase, when work was started on amending Part 4 as part of the overall project of amending the Civil Code. Why amendments were made of Part 4? I have mentioned that many times in my presentations. The reason was that its initial version had nothing to do with the modern digital age and the need to take account of copyright protection and other intellectual property protection of digital content. So here we needed some assistance on the part of those countries and their legislations where some experience had been gained. There's no time for me to go into detail, so let me cite just one specific example of how it worked. It's new Article 12.53.1 on the liability of information of intermediate entities or information agents. There's a EU directive made up of 4 articles. So if you analyze this new article of the Russian Civil Law Code, you will see that that directive was, of course, reflected in it, although the conclusion is that other countries' experiences must be studied, but then implemented wisely, because it has to fit into the country's existing law. Yes, remembering the structure of the soil and climate you are growing it on. Now, the work was very thorough to adjust it, and now it deals with providers that simply convey information or data, and other providers in the final phase of the bill's discussion. You can see it at the website of the State Duma Committee on Legislation. That's the only place where you can read it now, as of now. And there you will see that the main provisions of Article 12 in the EU directive are fully repeated, that the data agent is not responsible for the results of copyright transfer if they don't make any changes. The second type of agents that are relieved of liability are temporary storers of data where data is cached. This type is not mentioned in Article 12.53.1 because there's a special provision in Article 12.70 and then respective articles on associated rights, stating that short-time technical copies are not regarded as reproduction, hence it is not a type of usage, and there can be no liability for that. This is also a wording based on another directive, another EU directive, on the harmonization of certain copyright and associated rights aspects. Its preamble states that free use of those temporary copies is possible within these limits, and the wording that our current law has is not exactly in line with the EU directive, but because the issue of providers and caching has emerged, it has been modified and amended or expanded to say that I think I am behind myself. That this temporary record should only be in line, be carried out for the purpose of lawful use or have no independent economic significance. This has been brought closer in harmony with the European directive. Another type of information agents that are relieved of liability are persons and entities providing space or so-called host providers, hosts. They are not responsible. They're not liable under Article 1253(1) if they did not know or were not supposed to know that the use of intellectual property rights were unlawful, but when they learn from the copyright owner about the violation, they must take adequate measures to terminate this violation. And unlike the EU directive, it states such violations, it describes such violations more completely. The copyright owner needs to submit an application in written form. But of course, details have to be worked out in a special regulation or law. So this article specifies that the list of necessary measures must be stated in a law without specifying what law it is, and if such a law is not passed, then it will be sufficient for judicial practice to establish what measures are seen as necessary, but we still hope that such a law will be passed.
And thank you. Our next speaker is Dr. Hank Snyders, representing the Leiden University. Professor, the floor is yours, please.
Thank you, Mr. Chairman. Thank you for the occasion. I express my gratitude to be invited to say something about the culture of the Dutch Civil Code, which dates from 1992 for the main part. And I would like to add that I admire your recodification project. I remember that the Dutch Civil Code was translated into Russian, possibly Russian, Chinese, and some other languages, but also the Russian language. And I would be very happy if you would give us a contra present by translating the recodified civil code from Russian to Dutch. So we would like to learn from everything you do now in your recodification project, for I'm sure that we can learn from each other continuously. I have 10 minutes, as the chairman said. That's not too much
for a lecture on the culture of the Dutch Civil Code, but I refer to a play which I saw in London several years ago. There were some American players. They played the complete works of William Shakespeare in 90 minutes. And I thought that's impossible, but they finished after 85 minutes. And then they say, well, let's try it again. We do the complete works of William Shakespeare in 5 minutes. I thought they will not succeed, but they did in 4 minutes. And then they decided to do the same, but then in the opposite direction in 1 minute, and they succeeded. I will say that I will not do my speech in the opposite direction. I think that wouldn't be good this time, and certainly not after so many hours of your approved of the very, very kind attention. The culture of the Dutch Civil Code, what I mean is that I would like to say something about the basic views which are the views of our civil code as it stands now and as it stood approximately in 1992. I think that if I compare the Dutch Civil Code of this time with the Dutch Civil Code of 1838, the original one derived from the French Code, that we can say that the trust in the judiciary is much more a basic of the Dutch Civil Code now than in former days. The idea that the legislator, only the legislator, would be qualified to make legal provisions has been abandoned. On the contrary, more and more we see the legislator decide to a certain development, to a certain degree, that development of law had better be left to the judiciary than laid down in detailed codes and other acts. And nowadays, the question is no longer whether the judge is allowed to make law in the Netherlands, but in what situation the legislator or the judge is better equipped to do this. There are at least two types of situations in which the legislator will leave the development of law to the judges. First, the legislator often prefers lawmaking by the judges if there is a point at issue which he cannot oversee. For example, the question of the specific conditions of, for binding third parties to contracts. There are a lot of provisions on that matter, but in general, there is no provision on the question whether or not third parties are bounded or can get rights from contracts made by two other persons. That's one example. Another example, the legislator left it to the judge to say something about and to the development law on the question of broken off negotiations. There's no provision on this subject in the Civil Code. The legislator left it to the judges. Second situation, the legislator prefers lawmaking by the judges if he is of the opinion that the circumstances of cases with regard to a certain point of new law are too different for a legal provision to answer the question in detail. There are a lot of cases in which you say, well, there are a lot of circumstances which are important for the decision, but it's difficult to rule it in detail in legislation. I give some examples of very open legal standards, showing what I mean. Article 13 of the third book of our Civil Code provides that the holder of a right may not exercise it to the extent that its exercise constitutes an abuse. Under Article 6, paragraph 2 of, I must say, Book 6, Article 2, it's provided that a creditor and debtor must, as between themselves, act in accordance with the requirements of reasonableness and fairness. And the same provision applies to contracts in particular. And then a final example, 162, makes it clear that not only illegal behavior and the violation of a right of another person can be tortious, but also behavior which can be qualified as improper social conduct. So there are a lot of open legal standards, and meanwhile there's of course the idea of the legislator, but dear judge, try to make sub-rules, try to make sub-rules and so on. There are loose leaves in the Netherlands, and nowadays I can better say e-publications on extremely large amounts of case law, doing nothing more than giving sub-rules and sub-rules on open legal standards such as the open legal tort provision and the open provision on contracts. Of course, we still accept that the legislator has the last word in the making of legal rules. This just makes it simpler for him to leave some lawmaking to the judge in the first place. He's able, if he wants so, to change the case law very, very quickly. And sometimes it happens. Sometimes, and more, it happens, I think, that the legislator decides to codify what the case law has made, what the Supreme Court has decided in a lot of cases. A trend in the case law can be codified, for instance. So these open norms and also blanks resulting from non-regulation demonstrate the legislators' trust and belief in the judiciary, and the Judicial Organization Act even provides that our Supreme Court does not only have the function of caring for the protection of rights of individuals, natural persons, legal persons, and for the unity of law, but also for the development of law. It's very expressly a task for our judiciary to develop the law, of course, in general, within the limits of legislation. Another cultural aspect of our civil code is the interest of the common man and the public interest. What we did in 1992, but in earlier times too, to a certain degree, and there's still more attention to it since 1992, is serving the interests of the common man. Before 1992, we already had protection of tenants, protection of employees, and since 1992, I think that the most important protection of individuals is protection of consumers, especially protection in the context of B2C transactions, contracts. And the public interest is important too. Public interest is mentioned in some provisions of the present civil code. Sometimes it's called social interest, but it is a new development that in the private sphere, that in civil law context, also the public interest, the social interest can be relevant. Finally, I would like to say something what is the most important thing, I think, in relation to the main issue of the rule of law during this most interesting forum, and that's the introduction of collective actions in the Dutch Civil Code. I mean actions which allow a legal person to go to the court in the interest of other persons, individuals, or in the public interest. So we have so-called group actions. A legal person acts for a lot of individuals, and public interest actions. The legal person acts for some public interest. I give two examples. The first is an example of, it's an old one, but still very interesting in my opinion, the action of the Association of Medical Specialists in the Netherlands. They succeeded in convincing the court that a tariff regulation of the Minister of Economic Affairs has to be rendered operative. So an action of an association in the interest of the medical specialists contra the Dutch Minister of Economic Affairs. It was a very interesting decision of the Supreme Court. And I give another example, only one due to the time limits, an example of a collective action in the public interest, the so-called Nieuwe Meer decision. It's a lake near Amsterdam. And the Supreme Court decided in this case that the claimants, environment organizations, were admissible in their claim, which provided that the municipality of Amsterdam had to stop dumping dredge spoil from the Amsterdam canals in the lake. It was a very important decision. And altogether, I think that I may say that this possibility of group actions and general interest actions, collective actions, will be supplemented in future, and that these actions will increasingly fill the need for effective access to the courts in conformity with the rule of law, effective access to the courts for ordinary people who can be happy that legal persons serve their interests as far as they do not object to this. In the author's opinion, in my opinion, the culture of the civil codes as such will not change significantly in the coming decades, but the techniques for realizing civil rights will be even more sophisticated, including supplementary techniques for those collective actions, all in conformity with the rule of law. Thank you, Mr. Chairman.
Thank you very much, Professor, for your presentation. And we now have a concluding presentation from Madam van der Molen, lecturer on private law, lecturer on private law from the University of Applied Sciences in Rotterdam. Thank you very much, Mr. Chairman. I have to thank Professor Snijders for making such a beautiful introduction to the project I'm going to describe right now. He has drawn your attention to some very important aspects of the private law of the Netherlands. My project deals with the translation of the Dutch Civil Code into Russian. Professor Schneider has mentioned that an attempt of such a translation has already been made. That happened back in 1996. That's 17 years ago. The Civil Code has been revised, it's been extended, it has got some new volumes, some new books, and my colleague and myself are planning to translate that as well. Most importantly, the translation is carried out by two lawyers. I graduated from the Erasmus University in Rotterdam, and my colleague graduated from the Saratov State Law Academy, and she works as a judge and as a public prosecutor in one of the courts of the Russian Federation. We have presented the translation to quite a few experts and organizations. Our translation was appreciated by Professor Feldbruck, who fathered the translation, the first ever translation of the Dutch Civil Code. And also we got an approval from Mr. Kolotkin, the ambassador. The principal issue, the key problem of the first translation of this Dutch Civil Code into Russian were the problems of quality and accessibility. The legal practitioners believe that the quality is not up to the state-of-the-art standards, and the translation is not available to the public at large. Back when we worked, my colleague and myself worked for a lawyer in Rotterdam. We could see that many economic entities based in the Netherlands had to get access to the Dutch Civil Code in their own language. There was no such possibility, so we decided to provide them with this access and undertook this titanic effort. The pilot copies are already available, and they are available here for all of you. You are welcome to finger through the translation and see what the quality is. As we were proceeding with the work, we could see that it may be an important source of research for comparative analysis that may be of interest to different organizations. Actually, I don't think I'm going to use any slides I have prepared for my presentation, because everybody present here are sure to understand the significance of an accurate translation of a document like a civil code. Let me tell you about the problems we had to face. First, we did not have a good editor. We do not have a good editor even today, and I would like to appeal to teachers and professors of law schools. If anybody is interested in acting as an editor or a proofreader of the text, you are welcome to come and talk to us. Also, we are looking to raise the funding for the project. If anybody is interested in helping with the funding, you are welcome to come to talk to me, and I will tell you more about our timelines and the exact scope of work. Well, this is very briefly it. This takes care of the presentation I have prepared. I'm sure I've made my subject and my issues very clear, and I remain hopeful of getting some interest from this audience. We have several editions of the translation, but so far we are not happy with the results. Thank you very much.
Thank you. I believe that we'll really think about editing, and you could also contact the Private Law Research Center. You have received a question. I cannot hear the person asking the question. Now, the author of the written question does not insist on an answer. If you don't insist, it's okay, but I am ready to take it. I disagree with you. People seem interested, and we could really have an argument. When will I have such an opportunity? Next time. The question is, were you not too much in a hurry with regard to requisitioning in civil law? Yes, one could argue about it in the light of the recent events, And for me, what follows from the most recent events is that the investigative committee has begun working hard. It is there needs to be a penalty in the criminal code rather than civil code for those offenses, and we have looked at the relationship between penalties in the criminal and civil code. We looked at where this provision is used by courts of arbitration, and we have seen attempts at using it in taxation law, and this had to be stopped by special decision of the Supreme Court of Arbitration. Or I could cite the example of a cassation case when the court was considering a claim by the prosecutor's office about some medical research institute that made a contract with mortuary for the corpses of unidentified persons to be handed over to them to teach students and make experiments. The prosecutor's office started action about the need to stop that, but then we have to ask ourselves, what should we do with that? And I'm talking with those corpses, and then it's a matter of actual judiciary practice. It doesn't work here, and I think they left it just in case that provision. They put the hammer into the pocket, but now they need to run races, and there's the hammer in the pocket. And now, the second question that was asked is this: the commentary on Article 178 saying that a court may nullify a transaction if the intent of the party in tort could not have been detected by the other party working on a bona fide basis. This was compared with the experience of Italy, where the recognizability of avoidance is a criterion. If I was under some mistake, or if I was making a mistake, but if it was detectable, or if I deluded you in such a way that it cannot be detected, then you cannot dispute the deal. We are expanding reasons for disputing transaction, but on the other hand, we introduce counterbalances for it not to become a broad basis for nullifying a wide range of transactions. And this is a case of how foreign experience is used. Now the question was, is it not a misprint, not recognizable? Well, the person that made mistakes was probably able to realize it was making a mistake. No, if it was a mistake that was such that could be recognizable by a person, now it means recognizable for other persons or entities or counteragents in the deal. Okay, I have two questions to you. Question one, are there more questions? Yes, there seems to be one. Briefly, please. Be brief. Even the technical devices are collapsing. I will repeat my question. It's object ownership in the draft civil code. We have had the concept of two statuses relating to movable property and plots of land, the right of ownership and the right of lease. Now the draft changes those norms vastly. And what are the reasons for the need to change this regulation? Because practice has taken shape. It's either ownership or lease. And how do you think those changes will affect the practice? Because many things will have to be changed in practical terms. Well, I'll try to say a few words, although the expert group on these issues on property law was the group of which I was not a member. You said we have the right of ownership and the right of lease, and we are happy with these property rights. It's strange when lease is considered as a property right. It's a contract, a relationship. But this has indeed taken shape in this distorted world of ours. What is considered as an obligation in the normal world has turned into a multifunctional tool that services varied interests, like the interests of developers ignored under the new code, and lease services quite a number of interests, like a magic wand. It might replace trust if needed. This leads to internal conflicts because it does not fit into the lease ideology, because we say lease meaning development or lease meaning something else. We need to harmonize that, bring that into conformity with the sense that these words have. And of course, it will be painful. It cannot be painless when we have a system inherited from the old type of command economy, where there was no need for a variety of proprietary rights. But now the market has this need, and we need to introduce it. And that it will be complicated, I agree. There's no other way. When you have no leg, you need a prosthetic, and that's a complex device. When drafting those amendments, did you assess the scope of practical and economic costs that companies will have to incur to transfer what they have as a lease to development rights, etc. Well, ideologically, developers wanted a temporary or transitional law to be adopted for this transition period, the period of transition to another type of proprietary right. Whether it will come out this way or not, I don't know. One draft law was cut into 9 pieces like a sausage. This already has led to disagreement and conflict, but this was the decision taken by the State Duma, and now, as some journalists say, we pass them by way of as patchwork. The question you have raised was really given a lot of consideration at the level of concept and at the level of the initial bill, but now to keep all those pieces of legislation in harmony with the entire system is impossible. The situation has become complicated because the draft law has ceased to be one. No one thought that one bill would be cut into 9 pieces. This is an unprecedented thing. Since there had been no precedents like that, we had never expected such a nightmare. It's a nightmarish thing. It's indeed scary, and maybe we need the legislator to learn not to do such things. Maybe. Well, shall we start a discussion? This is my second question, or no? We have 2 opportunities to start a discussion and stay here for another 3 hours, and the other option is not to do so. Just learn lessons from what has been said, take it into account. The point of the discussion is not to come to an immediate agreement about something, but to isolate issues of disputable nature so that we can still consider them while there's still a chance. For example, possession was made frequent references to today. It's here in St. Petersburg. This concept is criticized. So let St. Petersburgers deal with it and see whether they're going to defend this concept or not. No, Boris Borisovich was not among the drafters of this bill. I don't know what position he would take, but he would weigh things out thoroughly. It's our common teacher. I used to listen to his lectures. He's the founder of the Ural Civil Law School, and then came to St. Petersburg. So my impression is we are not going to start a discussion. Let's just take note of everything that has been said, and remember that corporate management, corporate governance in the civil law of the Netherlands is regulated on a statutory basis rather than by contracts or agreements, because attempts are being made here to substitute statutory regulation by contractual agreements, even with the involvement of outsiders who have nothing to do with that, and those governance solutions may be held in secrecy. That's very convenient for some, and this has become part of our law through the law on economic partnership. But we believe it does not strengthen the legal foundations of Russia's economy, and this is really a source of great apprehensions. And it's a good thing that only 2 economic partnerships have been registered under the new law, and they were both car parks. So it's nothing serious so far, but who knows, maybe some people will make use of this tool and then will reap a tempest. No, but it's good that we have common ground on corporate governance. And we also are having active discussions of case law, and we can witness them in Europe as well. I consider this as a certain rapprochement and enrichment of legal systems. In the Anglo-Saxon system, I can see the advance of statutory law. And rather than case law, but in continental Europe and here in Russia, judicial practices are the practices of the judiciary are beginning to play a role too, and this may be a useful thing. And the same can be said of group actions and the need to protect consumer rights, public interests. Here I think we are marching in step with our European colleagues. The influences of Anglo-Saxon practices on our law, well, I assume that here in Russia we should not try to run ahead of the United Europe, because the EU is a test ground for the joint functioning of the continental system and the Anglo-Saxon system, and we should look and see how it works and borrow whatever seems useful. So I would not really borrow unchangeable institutions from Anglo-Saxon laws, like unnamed contracts, anonymous contracts. Maybe they will play a positive role, maybe they'll soon be forgotten, and we need to look at these things without actually making it statutory law. Yeah, and tomatoes as well. I think we must not create obstacles here, but we should not be in a hurry so as not to violate the systematic foundation of legal regulation. If we don't want to lose lawfulness, we should not disrupt the legal regulation system. So let's be looking at what Europe is doing, and we should not run ahead. And don't try to outpope the Pope. Let the Pope be a little holier than us. I quite agree. And indeed, during this forum, especially when our guests touch on policy aspects and sometimes try to assess us or teach us, I will be quite frank, we don't quite like that. And the reason is that Russia is a country that is starting all this not for the first time. We are proud of our 19th century in Russia, because in the 19th century, not only Russia, but the world at large received beautiful literature, poetry, music, and painting from Russia. And in the field of law, we also had great achievements. In the first third of the 19th century, we had the collected laws of the Russian Empire, because we had an outstanding lawyer, Mikhail Speransky, who was the initiator of that. And in the 19th century, a system of commercial courts emerged, again initiated by Speransky, and it was quite a modern system because it was based on the principle of competition, out-of-court and pre-trial settlement. It's amazing, and we are reinventing all those things again.
When my American colleagues tell me, of course, it's so difficult for you to work in your country. You only got your bankruptcy law in 1992. Remember, in the United States, the law appeared 100 years before that. I would not always get involved in this discussion. I do know that in Russia got this law 60 years before the United States did. Russian history is extremely rich, but we tend to forget a lot of it sometimes. We have lost some of it, true, but the pre-revolutionary law used to be studied at universities. We do know what institutions we had in the old days. We are not creating lots of things from scratch. We are restoring lots of them. Back when I learned about the commercial courts in the old Russia, I didn't have to discover much. I just went back into the past. We have not restored that whole system. We're still in the process of reviving it. We did have a very rich practice in pre-revolutionary Russia of lawyers participating in trials as barristers. But the experience of the modern world is extremely important for us. So we would like to thank all the foreign participants and speakers, our panelists from other countries. Thank you very much for contributing to this panel discussion. We appreciate your contribution ever so much. The Civil Code of Russia, the current Civil Code of Russia, is largely a result of our joint effort. We cooperate tightly with our colleagues from Holland, because some time ago they were completing their revision, their modernization of their civil code, and we did take advantage of lots of their achievements. Same as Peter the Great went to Holland to learn shipbuilding, we built the vessel of our civil code, largely capitalizing on the Dutch experience as well as the experience of our French and British colleagues and Spanish colleagues as well. I hope that our cooperation goes on. We are very open for any further cooperation and collaboration. I would like to thank all the participants of this discussion. Thanks to all the panelists from Russia and abroad. I see here familiar faces from Kazakhstan, from Belarus, and from other nearer abroad countries. Sorry for having been such a tight moderator. We've spent 3 tough hours with very strict time limits. I could not help it. I'm sorry, but I had to. But I believe that we have achieved the purpose of this panel discussion. Thank you so much.